Okay, I'm recording. So, Netlaw, IT company that was created out of an estate planning law office in Louisville, Kentucky. That's where I'm from. And like I said, at the law office, we only served wealth clients, but we were only servicing a very small fraction of our community. And with 60% of Americans not having a will, that was really unacceptable. So we all sat around and had just a conversation, a business planning conversation on, what do we do to make sure that more people have estate planning taken care of? And the easy answer was technology. We needed to create technology that we could get to everyone so that everyone can use this. So thus Netlaw was created. And how was it created? We worked with attorneys in all 50 states. So we have a lead attorney in all 50 states, and they helped us build a template. Each template is state specific. So when you go through a Netlaw plan, you are getting state specific documents from the state that you live in. So if you're in Texas, you're getting Texas state specific documents created by an attorney. If you're in Kentucky, where I'm at, same thing. You get Kentucky state specific legal documents created by a Kentucky attorney. And so that template is what led us to be able to go out and market this to people to say, look, there's a better way. In 2012, we won the James Keene Award from the American Bar Association, who said that we had the best online delivery of legal documents. So far, we are the only one in estate planning that's ever won this award. So you think about some of our biggest competitors, right? LegalZoom, LegalShield, we've all heard of them. They spend millions and millions of dollars on advertising. They haven't won this award, mainly because they focus on everything, right? The great thing about Netlaw is all we do is help people with their estate planning, and we only offer 5 programs. Now, even though we offer 5 programs, 90% of what we do is the second column. It's the premium probate avoidance package. This has all the documents that you're going to need for a comprehensive estate plan. I'm going to take the time now to run through everything that's in this column, and I'm really going to focus on that second column. We'll talk briefly about the other 4, but everything that we do focuses on the second column, and everything in that column you get for $600. So let me go through them. And the first one is the will, right? When you think about estate planning, everyone always asks, hey, do you have your will and trust? That's what they always talk about. So let's talk and start off with the will and why a will is so important. There's 3 reasons. 1, you're going to name an executor, someone who's going to be in charge when you pass away. Who's going to handle everything? Who's in charge? That's your executor. The great thing is your executor can be here in the US or they can be from overseas. So important to make sure that the person that you choose is available for this, right? And we give you that ability to do that. So the role of an executor, right? Making sure that the assets get to the right beneficiaries, making sure that your final taxes are paid, making sure that all your bills are paid, right? Even though you passed away, you still owe all of this. You still need to file a tax return at the end of the year. So that's the role of your executor. They're in charge, right? The second reason we do a will is guardianship of minor children, right? If you have a child or children under the age of 18, they're minors, right? So if something happens to mom and dad, who's going to take care of the kids? We need to make sure that we name that. And again, this can be someone here in the US or someone overseas. The third reason and final reason you do a will is you get to list your assets and who the beneficiaries of those are going to be. So very important to make sure that, I want this person to get this asset. You have to put it in your will. And we'll get into all of that a little bit later. But I wanted to kind of give you a reason of why a will is so important. And as you go through this, you're going to realize, and I know a lot of you are from India, and in India, it is very easy to do your estate planning. Everything gets passed down to your spouse or the kids, right? The next generation. Here, it's not that easy. If you die without a will, it's called intestate. And that means that the court system comes in and decides what happens to your assets, right? What happens to your kids. We'll get into all that a little bit later, but I really wanted to make sure that you understand the importance of creating your estate plan here in the US. So we talked about a will. Inside the will also is a children's trust. If you want your children to receive their inheritance at age 18, absolutely they can do that. But we have the ability to string that out a little longer. Maybe you want to give it to them all at age 25. When they get a little older, they're a little bit more mature. Maybe you want to give a little bit of it to them at 21, a little bit at 25, and the remainder at 30. The percentages and the time frame is up to you, right? You get to decide. And that way it helps them. If they're not, like me, I know if I would have received a lot of money at age 18, I would have blown that. It would have been gone. I wouldn't have thought about the future. And that's just how I was. And I'm sure a lot of kids were like that. So we have the ability, even in death, to be able to take care of our children with the Children's Trust. The third document is our power of attorney. We've all heard of that, right? Our financial power of attorney. Someone who can help you make your financial decisions for you if you can't make them for yourself. How important is that? If you're in the hospital and you're sick, someone can help you. But how about if you're not sick? You're perfectly fine, but you were trying to sell your house, but you went to India for vacation, right? Your POA can help you sell your house, right? They can help you with all kinds of things financially. The next three documents that I'm going to talk about is your healthcare decision documents. And these are just as important as your financial documents, right? Healthcare surrogate. That's almost just like the same thing as your financial power of attorney, but for medical decisions, right? It's your medical POA. This is a person who's going to speak to the doctors and nurses on your behalf, making sure that your wishes are followed through. The HIPAA authorization allows someone to look at your medical charts, your psychotherapy notes, so that they can help make an informed decision with the doctor. And usually your healthcare surrogate and your HIPAA agent is the same person because those documents work hand in hand with each other. And then the last one, the most important in my opinion, is your advance directives. It's called a living will in some states. And that's your end of life decisions, right? Do you want to be hooked up to a machine, fed nutrition intravenously, just so you can be kept alive longer? Or the opposite, when it's time, just let me go. I don't want to be a burden to my family. I don't want undue medical bills. So either option is your choice, right? So we want to make sure that your wishes are followed through with your medical decisions as well. We have a pet trust, right? As I said, I'm from Kentucky, horse capital of the world. So for our clients that came in, a lot of them had horse farms. That's how the pet trust was actually created. But really it's for, your dog or cat or family pet, right? If you pass away, who's going to take ownership of that animal? You can leave a little bit of money behind so it's not a financial burden for that person because vet bills are expensive. If you have a dog or cat, you know how expensive the vet is. It's ridiculous. Boarding, food, right? Stuff like that. So the pet trust really does come into play for a lot of people. And then the last document, which is the biggest, in my opinion, it's our probate avoidance revocable living trust. And the best way that I can describe that trust is that it's a holding document. It holds all of your major assets so that you avoid probate. And if you don't know what probate is a process when you die without a probate avoidance trust. All of your assets are frozen, anywhere from 30 to 180 days. Now, that gives time for creditors to come in and take what's owed to them first. Then what's left behind is passed to your beneficiaries. Now, if you want your assets to be passed to your beneficiaries right away, you just fund your assets into our probate avoidance trust. And even if you have property in other states or overseas, you can still put those properties into your trust. You don't need separate trust. You can do those all in one trust. So how important is that, right? Now, all of these documents that I just talked about for $600 is the plan. In our law office in Louisville, Kentucky, it's anywhere from $3,500 to $5,000, depending on which attorney you talk to. And it's a lot higher in your big cities, New York, LA, Dallas, Chicago, all big cities. So for $600, what a deal. And why is it so inexpensive? We've already paid the attorneys. We've already had the attorneys do their work and they're done. Now you just go in and fill in the template. The template asks you a question and you answer it. It's that easy. The program also comes, I call them comes with, right? There's always stuff that comes with it. We have a Life Vault, and the Life Vault has over 100 gigabytes of data, so you should never run out of storage space. And this is where you can go in and store all of your important data in one secure spot. Now, we just completed our SOC 2 audit, so security is always something that we're worried about, and making sure that we're on top of it. We use Microsoft Azure for our backend help, downloading and all that. So security is always on our mind, so we want to make sure that you know that. The spouse's plan is included. So not only do you get to create your set of documents, your spouse gets to create theirs. Full set of documents. And it comes with a 30-day money-back guarantee. You try it out, you don't like it, we'll give you your money back as long as you don't download any documents. All that for $600. If you can't afford the $600, we do have a monthly financing. It's $60 a month for 12 months. Whether you do the $600 up front or the $60 a month, you get to start your documents day one. The first day that you purchase the plan, you get to start your documents right away. All of these documents are revocable. That means you can go in and change them at any time. You can store as much as you want into your documents at any time for the first year. After the first year, to keep your plan open and active, it's just $8 a month. That's an optional plan. If you choose not to do it, no problem. You just cancel. Everything that you've stored in your vault for that first year is yours, and you can always get to it. And we have a reinstatement policy if you want to come back later. And the most you'll ever pay to reinstate your plan is $250. We're not going to have you charge the $600 again. So like I said, 90% of what we do is this plan right here. I'm going to briefly talk about the other 4 plans, but as you can tell, it's only 10% of what we do, so I'm not going to spend a whole lot of time on this. The Essentials plan is the $400 plan. It's the same exact plan as the $600 plan, except it does not have the trust. And we have already talked about how important that trust is, making sure that your assets get to the right individuals at the right time. We have an ILIT, Irrevocable Life Insurance Trust. This is the only document that we have right now that is irrevocable. You can't change it once you create it. And remember, this is just a life insurance trust. So you would need to have a lot of life insurance for this to be a viable option. We always say 5 to 10 million to start in life insurance, but it does help out with the beneficiary on taxes. And there are some other things that you can talk about. Talk to your agent about it and they can help you out. And then the 2 starter packages for $99. We created this for 18, 19-year-olds, right? They're adults, but they don't own a home. May not even own a car. So they didn't need the full plan. They can upgrade to the full plan later. But right now, just to make sure that they're protected, we give them the power of attorney and the 3 healthcare documents for $99. The only form that's different in the student package is the FERPA consent form. That's for college. That's a form that the student signs, and it gives permission for the parents or the guardians to be able to call up the school and ask about grades, conduct. If the student's hurt, the school can call the parents and let them know what happened, right? Without that form, the parents can't find out anything. The student's over age 18, they're legal adults. Even if the parents are paying for college. They do not have the right to call. So very important form. But again, everything is included in the $600 package. And remember, I always like to reiterate, $8 a month after the first year, right? To keep your account open and active so that you can change any document at any time. And I created this slide to kind of give you reasons of why you would ever want to change your documents in the first place. And I'm not going to go over all of these because it would take me an hour just to go through this screen. But I will point out one. How about relocation to a new state? It's right there at 3 o'clock. If you get your plan done through an attorney in one state, let's say in Texas, and you pay the $3,500 and you got your estate planning done, right? But then you got a new job in Kentucky where I'm at. Well, now you got to go to an attorney and get your documents done again because now you live in a new state. Every state has its own laws and you need to follow those laws. Well, now you got to go to a Kentucky attorney, pay the $3,500 again, and start over. The great thing about Netlaw is all you have to do is go in and change your address in the software. Reassemble all of your documents, and it's going to reassemble them to Kentucky documents. You print them out, and you get them witnessed and notarized. You're done. Value. This is why we created it. If we were going to have you spend thousands and thousands and thousands of dollars, we would have just told you to go to an attorney. We are keeping this inexpensive for you. And remember, they're all state-specific legal documents created by an attorney in that state. So I've talked about what Netlaw is and how we were created. I've talked about the documents that you get, and I've talked about why you need those documents. But I kind of want to drill down on just 4 major reasons why you do estate planning. And I think I like to talk about these 4 because it really it wraps it up into a nice little package. The first one is you decide who gets your assets. Well, without a will, that's not a true statement. Remember, in the US, you have to list your assets and name a beneficiary. If you don't do that, the state will come in and decide who gets your assets through a little legal word called intestate. Intestate just means you died without a will. And the state comes in and decides everything. Nobody wants the state making any decisions for them, let alone something as important as this. Sticking with the theme of states making the decisions, if you don't name a guardian for your minor child or children, again, a judge will come in and decide who's the best fit to raise your kids. Not you, the judge. And that's going to set off a firestorm in the family, right? Mom's side's going to fight over the kids. Dad's side's going to fight over the kids. Kids are stuck in the middle, right? They just lost their parents, and now everyone that they know is fighting over them. They don't need that. And this is a great reason why we do a will, right? We're already telling people, we've already made these decisions. You don't have to worry about it. You don't have to fight over it. We've already made these decisions. Third reason is avoiding probate. If anybody's ever went through the probate process, they will tell you. It's expensive. You have to go to court. You have to hire an attorney. Not fun. The best way to avoid probate is our trust. Probate avoidance, revocable living trust. Making sure that your assets go to the right individuals right away. And lastly, your medical decisions. I'm very passionate about this. You know, having your medical power of attorney is so powerful. Someone to speak for you when you can't speak for yourself. I always say, we're living longer as a generation. And we're dealing more with Alzheimer's, dementia, taking care of our parents, right? Well, you want to make sure that their decisions are followed through with. You want to know what their decisions are. If you don't know, you're just guessing. What would mom and dad really want, right? Being their medical power of attorney and finding that out helps with your end of life decisions. right? Your living will. Did they want to be hooked up to a machine and kept alive as long as possible? Or did they just want to pass naturally, right? Making sure that their decisions are followed through with is the best thing we can do for them and ourselves, so that our kids don't have to do it and they don't have to wonder. So I'm very passionate about the healthcare documents, as you can probably tell. So I'll finish with this slide. Why Netlaw? Personal, right? I've talked about it the whole presentation. Making sure that your decisions are followed through with. And how do we do that? Conversational. Let your friends and family know that you've created your estate plan. If they don't know and something happens to you, how do they know where the documents are? How do they know they even exist? Digital, right? We're an IT company. We're open 24/7. Why? Because the web's open 24/7. You can log into your account anytime you want. You can print anything out of your vault. You can change any document anytime you want, as long as you have an open and active plan. You can store anything into your vault. And think about that vault is so important. That's where you can keep deeds to your house, titles to cars, right? Passports, pictures, videos, your estate planning documents, your taxes. That vault is so important. And then lastly, I put done. If you watched the video before we came on that Theru showed, 60% of Americans don't have a will. That's not our number. That came from a Bloomberg report. 90% don't have all the documents that we offer in our $600 plan. A comprehensive, up-to-date estate plan. And remember, we won the James Keene Award from the American Bar Association. Best online delivery of legal documents. The only one in estate planning to ever win it. If you ever need to talk to us, this is our phone number and email address. Always contact the person that invited you to this webinar. They will help you to get started. Any questions? And if they don't know, call us. I have trained a great group of customer service reps. All of them have been trained by me. So when you call there, you're getting the best support you could possibly get. And you have great agents. All right, guys, I am going to turn it back over to you. And Theru, if you want to add anything, maybe anything that I missed or a certain perspective from the Indian community, or we can go right into questions, whatever you guys want to do.
Yeah, you did. Yeah, you covered all major things and everything. I think it's good, Mark. Appreciate that. I think you added more points this time by keeping that Indian culture and in India we have a Hindu Undivided Family Act, and like for every religion we have a family act, like Hindu, Muslim, Christian. If there is any people in India who doesn't believe any religion, there is a common law which helps them. So according to that, we don't need to have write a will, and the inheritance, everything, unlimited inheritance will be passed on to spouse and kids and grandkids, like that, right?
Yeah.
So here, as you mentioned, that is clearly, yes, it works differently here, and right. So I think you covered it, and now we open up for the question answers, and you can take the questions, and if needed, I'll be part of it. Yeah, please, you can unmute yourself, everyone. Whoever has a question, one at a time, please feel free to ask. No question is simple or silly or a dumb question. Every question is valid for us, for you. Okay, please do not hesitate. Okay, this is very sensitive, very important. If you are doing it, do it right. Okay, if you do something wrong, means it's equivalent to you're not doing anything. So better, let's do it right, do it with pride. Any questions? I see, let me check the people. Some people did not mention the name. Anand, Anirudh, Bala, Dhaval, Gopi, and Jyoti Garu and Muthu, Rad, I don't know, Rad means Radhika, or, I don't know. Raizu, Raj, Ravinder, Shrikant, Suresh, Suveen, Umashankar, Vidyarthi, and Sam. Some of the people do not put the names, like they put iPhone or phone numbers. Feel free to unmute your phone or your audio and ask the question.
Yeah.
Mark
Let me add something that I forgot to mention.
Sure, sir.
For the month of June, we're doing our buy one get one free. So I forgot that. So if you purchase a fully funded plan, that means you pay the $600 up front, no financing option. You actually get the one that you paid for, and you have the ability to go in and give a plan away absolutely free to someone else. So the possibility of helping 4 individuals create their estate planning documents for $600, that's our way of trying to help the community. So if you are interested in this, this is the time to purchase it. So get with Srinivasa, and he can help you, or whoever invited you to this webinar, and they can help you get more information about that. But it's for the month of June. Buy one, get one free. Sorry, I forgot to mention that.
Sure, no problem.
So Raju here, can I go for the... Excuse me.
Yes, Raj.
Yeah, Srinivas, like I have seen, like you are helping us as a financial or otherwise like a real estate. So can you suggest us the like best area to buy a home, meaning that is in the that will be like a future as per the like income purpose, or otherwise if you want to sell. So I want like the which area you can suggest, that the right area for the Dallas, and which county or which zip code for future, just for investment purpose.
Raj, this is more of like a villain. So I think we will talk offline that. Raj?
Yes, yeah, please.
Yeah, we'll talk offline that one.
Yeah, sure.
This is more of like a will interest. Maybe Mark, you can add like what documents will go to will, and what documents of assets will go towards the trust. Maybe.
Mm-hmm.
Sure.
So
Thank you.
Yeah.
So the trust document, that's where, it's just a single document, the trust. And what it is, you fund your assets into the trust. You're not naming beneficiaries to the trust. You name that in the will. So the trust is just the place where you take your documents and you fund it over. And what I mean by that is, so if you're going to put your property into the trust, it's really easy. You take the deed to your house and the title or the trust that you created with us, contact the county clerk's office, and just go down there and do a deed transfer. You're taking the deed out of your name, your personal name, and putting it into the name of the trust. And then that way, that's what avoids probate. Because items that are in a trust are private. If they're in the will, they're public information. That's why probate avoidance is in our trust. It's private.
Question mark. So probate avoidance always comes up in the trust, or trust can be without probate also?
No, the items have to be in the trust for it to avoid probate.
Sure, but if I just have a will and a trust, does that mean that I'm avoiding probate?
As long as you fund your assets into the trust, those items will avoid probate. Any item that's not in the trust will go through probate process.
Yeah, for Anand, for your question, answer is no. Just having a will and trust doesn't, will means yes, avoid the foster care for the minor kids and all those things, because we define the guardian, executor, trustee, all those things. having the trust means, okay, completing the documentation here, download, print, notarize the documents, make your trust is valid. That's good. But if you don't fund the trust with your assets, it could be bank account or a brokerage account or a personal home or any other real estate investments. If you don't fund the trust with your assets, you end up going to the probate. Is that correct, Mark?
That's correct. And we have in our vault, we have funding instructions that you can follow to make sure that you get your assets done correctly, or you can just call us and we'll help you.
And
We'll
there
tell
are
you what to do.
Yeah, there are a couple of scenarios where you can avoid the probate court is have defined the beneficiaries. For example, in the bank account, payable on death, POD. If you define the POD beneficiaries, or you can have the joint account with your spouse or your adult kid, right? And those areas, and will avoid the probate court. And another scenario, 401k and life insurance, definitely we define the beneficiaries, right? So those two also avoid the probate court. Where we don't get chance or would not put beneficiaries, the personal home or the car. When you buy the car or a personal home, or when you buy the investment, any real estate investment property, there they'll not section something like, you put the beneficiary, right? So those things is the we'll start with. But yes, that's how it works. And yes, Mark, please correct me if I'm anything.
No, you're right. And just to add on to that point, if you already have your trust with us and you go out and you buy a house, have the title company create your deed in the name of the trust. That way you avoid having to go down and fund it. Same thing with the car. Have the title company do the title of the car into the trust name. It's going to save you money and time.
Right. So whatever is this kind of car or house and so on, whatever is not added to the trust will follow the probate course. But if you have added some of these properties in the trust, they will not go through the probate process. Right?
Right. As long as you fund those assets into the trust so that the trust owns them, then those specific assets will avoid probate.
So I have a question. This is Santosh. So let's say you have an investment abroad, like outside United States. Do you have to add that into the trust?
I would always suggest that you do that.
Yeah.
You have more
Yeah,
overseas assets.
Santosh, yes, most of us came from India, and most of us have some assets in India, right? So when it comes to the attaching our Indian assets to the trust formed in America, USA, yes, it's possible, and we did help for a lot of clients, but we need to work with Indian chartered accounts or tax attorneys, because it has to follow some RBI rules, Reserve Bank of India rules, right? So answer for your question, can we attach Indian assets to the American trust? Answer is yes. How to? Yes, we need to work with India chartered accounts, and because they are familiar with RBI rules stuff. So they do, and they did, and they're very well familiar with that part. Okay. Another question, the major question, the question is, do we need to add or not? That's the question. So it's optional, but it depends on case-to-case scenario. Okay, we do as a part of financial services, we do the analysis and see the complete situation, then we recommend. We cannot recommend generic with the generic answer. Okay, it all depend on your net worth, your situation, all those things depend on, we could say, better advice. Okay. So
Okay,
because we do connect you to we'll involve our CPA and our attorney, and we'll give the right and first-hand advice, right? instead of giving the generic, which is not right, giving the generic advice, do it or don't do it like that, right? Okay. And yes,
One more question, Anand again. So if somebody have a will and trust done through some, let's say, attorney earlier, can they still come to Netlaw and do this version of live and trust? What happens to the previous will and trust?
Yeah, if you come to Netlaw and you do it over, this will take the place of the previous one. It goes by date signed. So the more current date signed will be the one that's legal.
Okay.
okay.
Do we need to mention those all previous wills and trust in the latest one that we have?
No,
previous
you
wills
do
and
not.
trust like that?
No.
Okay.
You're doing freshly, and whatever the latest executed document will be taken into the place, and the old ones will be, not going to work. That's all.
Okay. Sorry, I have another question, Anand again. I understand this Netlaw package offers the yearly and monthly payments for that. So let's say if I take a yearly package and do all my will and trust things, and let's say I do not continue after first year, and let's say after 5 years, if I have one more property, or let's say something changes, and if I want to update my will and trust, what is the process?
So what we do is we charge $8 a month for however many months your account was closed, but we cap that fee at $250. So the most you'll ever pay is $250 to reactivate your account.
Yeah, Anand, I want to add a few things for your question. Netlaw is not like a yearly plan or monthly plan like that. It's only the plan is when you pay the first time $600 or $750, those things, right? One-time fees, $600. First 12 months, unlimited updates you can make it to the documents, and that's it. Then, if it's optional feature is whether you want to enable $8 per month for the future because you're expecting some life-changing events. It could be new baby arrival or adoption or changing relocation, those things. Then we strongly recommend to keep that $8 per month, which is very, very helpful and economically, saving a lot of money. And so that's a way. But right, for example, whatever the assets you have as of today, you fund that assets to the trust based on the instructions we are providing in the funding instruction document. And down the road, maybe after 1 year or 2 year or 3 year, you are buying the new asset or, any new account like that. Those directly you buy on the trust name instead of buying on your personal or something else and again going through the process, okay, without making any changes to this document, directly buy the trust, buy the asset on the trust name, so you can avoid this extra work. Make sense, Anand?
Yeah, that definitely makes sense.
Yeah. Yes, Ravindra, it looks like you unmuted. Ravinder Banka, you unmuted, and you want to.
I have a follow-up question on the Indian law. So, for example, the kids are U.S. citizens, and we have an option to have them have the Indian assets to add here, but being a U.S. citizens, the kids, are they eligible to have the inheritance in India, or?
Very good question.
Yeah, so yeah, whatever inheritance you're giving them, they would receive. If it's inheritance from overseas, whether it be property or monies from a bank account, they would be entitled to that. If they're still minors, the executor and the guardian would work to hold that in trust, and they would still be able to pull some of that money out for educational purposes, medical purposes, if they needed a car to get back and forth to work, stuff like that. So there is ways to help that child or children with their inheritance, even if they're under the age of 18, or if they're over the age of 18, they can go ahead and acquire those assets.
Okay. Okay, thank you.
Yeah, another thing I want to add, most of us, on the field, we'll see that while helping the people and the webinars and seminars, I come across to this question. Hey, Tirmal, my kid's born in India and we are in H1 here, or B1 or L1, and or we say that we are not US citizens. Do we still need to write the will and trust? For that question, answer is yes, irrespective of visa status. Irrespective of visa status, everyone must follow the law of the land. Okay, that's the thing. It doesn't matter which status you are. The government have the default will if you don't have the will. The default will play the key role taking control of the situation. If both parents are passed away, the minor kids will be landed in the foster care, and assets will be seized by financial assets. So someone has to go through the represent and go through the probate process. So please, if anyone says something else, you don't need to write a kind of thing. Please clarify and validate, because it's very sensitive, very important. Always follow like this: trust and validate. We may be saying what we did and our experience. You can trust and validate. Okay, is this correct? Is the thing. Then take action. Don't simply trust or believe on something people something say and don't take any action or take action. Just always validate. Makes sense? So, yep. Any questions? Anyone? So 8 more minutes, and truly appreciate and respect everyone's time. And Mark, the weekend working, I think this is the second or third webinar today for you.
Yeah, third
now,
one today.
Yeah, now because many people are getting awareness, that, how the law works here and the rules in this country. Because of recently we have seen some very tough situations for some of the families affected. So I know we are all keeping you busy, and you can see that nearly 30 people are so much care about the family, and coming here and learning the things about what and how it works. Okay.
So,
Yeah.
I have one quick question on the for example, if I have a will and trust in India, the attorney in India do they have a jurisdiction in US properties at all, or do they have to have another will over here? How does it work if I have two wills? Two wills will work together?
Yeah, can you repeat your question once again?
No, the question is, suppose if I have a will in India, right, in an attorney, right, but I have some assets in both in US and India. So if I don't have a will here, does Indian attorney will have jurisdiction over the US asset at all?
No.
Not at all.
No.
So in that case, we have to have a separate then, or
yes. Yeah, the will, when it comes to the will, it has to be separate, right? So the rules and applicable things works in differently in both the countries. Only we were suggesting you can attach Indian assets to the trust formed in America based on Indian government rules. That part. So there is some confusion between will and trust. Okay. So people think that in India it's like a blanket will kind of thing. Okay. And in Telugu they say that tadanantaram means if it says everything how it go, we can write this kind of blanket will or kind of stuff. This is not like that in this country, so it doesn't go. But yes, definitely, as the beginning of the discussion, we are saying that we are not attorneys or CPAs and not allowed to give the legal advice, but we are sharing the information, what we experience and what we, train and by the Netlaw, who is one of the top, online estate planning portal. So yes, if there is any customization, if there is any more details in detail kind of thing, we strongly recommend take appointment with the attorney and see them, sit with them, and take action. Okay. And Muthu has the question, will and trust only belong only to US assets and legal stuff? Kids, not India assets to bother, right? India will and trust only. Whatever you write the will here, it takes only this country rules and other stuff. Okay. And US assets and US, legal documentation as per the US laws. It has nothing to do with the Indian, because it has to be separate. The will part is little confusing. In India, we think that a will means like a trust and everything, but here will and trust is two different entities. Will is the documentation where we define the roles and responsibilities for the key people. The key people, who are the key people? Key people can be your family members, relatives, friends, anyone. Is there any status restrictions for the key people? No. Is there any boundaries for the key people? Maybe not. But few states will mandate that the roles where Mark explained that executor, guardian, trustee, those roles. Some states mandate that the executor must be local. Okay, but not all the states. Okay, so executor, guardian, trustee, the three important roles play a key role in this whole process, and we can put as many people as we can, and those can be anywhere in the world and not it applicable for all the states, but like that. So we strongly recommend to have at least one or two people in each role, executor, guardian, and trustee, local to the city or state or country, so that they can immediately come into the situation, take a control. Okay, and that is a important role. And there is no limit on the number of people we can put in the things, and the same person can play as executor, guardian, and trustee role also. Okay, so that's where most of our clients put like 4 to 6 people in the key people at least. Then they define the role, hey, these are the executors, these are the guardian, this is the trustee, and some people will be defined in the multiple roles like that. Okay, so those things we need to, and Srinivas will share the link in the group now, the chat. Go through that. Yeah, go through that link. It has a very, very useful information. Srinivas, please post the link, your link on the chart, and please save that chart link, or he might be sent already to you in the meeting invitation. He's the link, or go through that link from beginning to ending. It gave a lot of information, very useful, and list out your questions, and let's set up the meeting. We'll do the needful for you.
Hello, a quick question. This is Devjit.
Okay.
So I have a will already. I have created a will through my attorney. Do I need to create this trust now, or it will be automatically created after the demise of both the parents? And if I'll create this trust now, it will be have any tax implication, I believe. So can you tell me whether is it required to build this trust now, or it will be required later?
See, those two are the two different sections, will and trust, right? So you may have only will, okay, and always have the trust to secure your assets, okay, and avoid the probate court, okay. And if you don't have the trust, and if you don't attach your assets the trust, you end up in the probate court if something happened to you, okay. Your beneficiaries, your family members, they need to go through the probate court process. They need to hire the attorney and wait for the probate court period appearance, then go through. So yes, always better to do the trust formation, funding the trust sooner than later, immediately, because never know. Why we are doing all those things is to make it our assets more private and secure, and avoid the problems in the future for our beneficiaries if something happened to us unexpectedly. That's what we are trying to say. We cannot say that do it today or don't do it now or later. That's not the right thing. But we are just showing the value of having the trust, why we need to have it, how to do, and make it your assets more private and secure.
Okay. No, actually, I thought my will is sufficient to create a trust. So that means I need to start building this trust now so that it
Yes.
will be helping later on. Okay.
Yes. Yep. Yep. 1 minute over 7. Yep. Appreciate everyone. Please be in touch with Srinivas, and he's one of my close friend and very honest, very humble person. Has a lot of passion to do any business with a service oriented, and so together we can help you address your questions whatever you can, and if not, we'll direct you to the right attorney, and of course they will have their own fee structure and consultation. But end of the day, our goal, our efforts, our intention is to make sure that you all protected. Family comes first, everything next. Okay.
Yeah. Thank you
Bye.
each and everyone for joining.
Yeah.
Taking
Thanks,
time.
Mark.
Thank you.
Yeah,
Thank you so much, everybody.
recording ఆపేస్తారా? Yeah.
Thank you.
Thank you all.
Yeah. Thank you, Mark. Thank you, Thirur.
Thank you.
Who needs to stop the meeting? I think Mark.
Yeah, Mark has that.
Srinivasa, are you going to send the recorded video?
Yeah, I'll send it.
Okay. Thank you.
Can you ping me the in the WhatsApp or in message?
It's recording. Can you please, Mark? Can you stop recording? Srini garu,
Yeah.
you're the host, or?
No, this is Mark's.